Harry Truman entered the presidency at a tumultuous time in American history. World War II was ending and a new era of Cold War was beginning. On the domestic front, the conditions were falling into place for Black Americans and other minorities to gain equality. President Truman had made no secret that he advocated modest civil rights legislation. But in 1946, when he established the Committee on Civil Rights to study and make recommendations on race relations, he sparked a firestorm in Congress and the rest of the nation. The committee's report on civil rights recommended the Justice Department play a larger role in protecting the civil rights of all Americans by ending Jim Crow segregation laws and eliminating discrimination. Truman backed this recommendation, and then, in 1948, he signed an executive order abolishing segregation in the armed forces and the federal government. After these moves, the Democratic Party split in half, spawning the Dixiecrats, a group of mostly Southern Democrats who advocated stronger states' rights. Even before Truman took office, change was in the winds. In Texas, where only whites were allowed to vote in the Democratic primary elections, a black man named Lonnie E. Smith sued county election official S.S. Allwright when he was denied the right to vote in the 1940 Texas Democratic primary. Smith claimed his 15th Amendment rights had been violated by the restriction. In Smith v. Allwright, the U.S. Supreme Court agreed.
United States law grants to all citizens a right to participate in the choice of elected officials without restriction by any state because of race. This grant to the people of the opportunity for choice is not to be nullified by a state through casting its electoral process in a form which permits a private organization to practice racial discrimination in the election. Stanley Reed, 1944.
Another important case that led to sweeping change in civil rights was Sweat v. Painter. This 1950 case involved Herman Marion Sweat, a black man whose application to the University of Texas Law School had been denied because of his race. When Sweat asked the state courts to intervene, the university said they would provide separate but equal facilities with a law school for Negroes. Sweat pushed his case on up the legal system ladder, claiming the university was violating the Equal Protection Clause of the 14th Amendment. The Supreme Court agreed, noting that the facilities of the proposed new law school for Negroes would be inherently unequal to those of the existing school. This decision was the first to punch holes in the Plessy v. Ferguson decision of 1896, ending the separate but equal doctrine in professional schools. It also opened the door for the landmark desegregation case of Brown v. Board of Education of Topeka in 1954. Dwight Eisenhower came to the Oval Office with a philosophy of dynamic conservatism.
In all those things which deal with people, be liberal, be human. In all those things which deal with people's money or their economy or their form of government, be conservative. Dwight D. Eisenhower, 1954.
Eisenhower had announced his commitment to civil rights. However, under his dynamic conservatism philosophy, he only acted on the federal level, deferring most civil rights issues to local and state authorities. But one move he made had a great impact on civil rights. Shortly after taking office, he appointed Earl Warren as Chief Justice of the Supreme Court. Warren immediately began stressing that the court should take a leading role in civil rights reform. During the 50s, more Black Americans were trying to enter the workplace and move into white communities. This forced desegregation to the forefront of the political agenda. Up to this time, blacks and whites went to separate schools, ate at separate restaurants, rode on separate buses, and drank from separate water fountains. The legality of this segregation was based on the Plessy v. Ferguson case of 1896, which established the separate but equal doctrine. But in 1954, this doctrine and segregation were put on trial in the landmark case Brown v. Board of Education of Topeka in 1954. The National Association for the Advancement of Colored People, or NAACP, had decided to attack the separate but equal doctrine. When the Topeka, Kansas Board of Education had denied a young black girl named Linda Brown admittance to an all-white school, her father filed suit. Brown's attorney argued that a separate but equal philosophy violated the Equal Protection Clause of the 14th Amendment. He claimed that even if facilities were equal in quality, the mere presence of segregation made equal education impossible and caused irrevocable harm to both black and white children. In its unanimous decision, the Supreme Court rejected the Plessy doctrine.
We conclude that the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Chief Justice Earl Warren, 1954.
A year after this landmark decision, the court ruled that the integration of schools must go forward with all deliberate speed. However, segregationists around the country organized massive resistance. State legislatures in the South passed nearly 500 laws and resolutions aimed at preventing the enforcement of the Brown decision. This strife would become a battle that raged in courtrooms, schools, and on the streets for another decade. The Civil Rights Movement took another huge step forward with the signing of the Civil Rights Act of 1957. This legislation enforced laws that ensured voting rights for Black Americans and put measures in place for preventing mob violence in school desegregation disputes. In 1960, another Civil Rights Act was passed to help stop violence in the South against potential black voters. It authorized the U.S. Attorney General and the Justice Department to appoint investigators for cases of voting fraud and obstruction. John F. Kennedy was elected on his promise of a new frontier. And one of the most pressing issues on that frontier was racial discrimination. Once in office, Kennedy went to work on a sweeping piece of legislation that would change the face of civil rights in America. In June of 1963, Kennedy made his position clear.
Who among us would have been content to have the color of his skin changed and stand in his place? Who among us would be content with the counsels of patience and delay? I shall ask the Congress to make a commitment it has not fully made in this century to the proposition that race has no place in American life or law. John F. Kennedy, 1963.
Kennedy proposed a Civil Rights Act that included providing black Americans with protected voting rights, banning discrimination in public facilities, establishing equal employment opportunity, creating the Equal Employment Opportunity Commission, or EEOC, and authorizing the Justice Department to initiate suits to desegregate public schools and facilities. However, before Kennedy could see his vision come to fruition, he was assassinated. When Lyndon Johnson took over the Oval Office, he picked up the civil rights baton and carried it for Kennedy. Though a group of Southern senators attempted to block the Civil Rights Act of 1964, it passed with overwhelming favor. In 1964, Congress also adopted the 24th Amendment, which ended poll taxes in federal elections. Poll taxes had long been used to obstruct poor black Americans from voting. The following year, the Voting Rights Act of 1965 was passed, which prohibited the use of literacy testing and provided federal registration in areas where under half of all eligible voters were registered. Soon after the enactment of this act, black voter registration increased dramatically.
This bill will strike down restrictions to voting in all elections, federal, state, and local, which have been used to deny Negroes the right to vote. This bill will establish a simple, uniform standard, which cannot be used, however ingenious the effort to flout our Constitution. It will provide for citizens to be registered by officials of the United States government if the state officials refuse to register them. It will eliminate tedious, unnecessary lawsuits which delay the right to vote.
A few years later, the Civil Rights Act of 1968 strengthened the previous acts by adding legislation that made racial discrimination in housing illegal and providing protection for civil rights workers.